Sands to address the court. You have the floor, sir.
Mr. President, members of the court, you have now heard the detailed, forensic and extensive evidence of Myanmar's acts against the Rohingya community. You've also homed in on the appalling events in 3 particular locations, Bingyi, Chut Pyin and Mang Nu, as well as other key places. You're aware now, fully aware, of the extensive and established pattern of conduct by the Tatmadaw across these villages and others in northern Rakhine State. A pattern that embraces extreme and brutal violence, killings, pervasive sexual harms, the targeting of children and women, the destruction of evidence, and then total impunity for every perpetrator. Mr. Suleiman brought to you in graphic detail some contemporaneous messages that were publicly circulated by the Tatmadaw on their Facebook pages and elsewhere as these terrible events were being prepared and as they unfolded. The UNFFM did not have the totality of the material that he took you to available to it. Nevertheless, it observed that there was a remarkable similarity in the timing of operations, the sequence of events, the types of weapons used, the assistance received from other security forces or ethnic Rakhine, and division of roles between perpetrators, the types of violence and the manner in which they were committed. With those Facebook posts, we now know that the remarkable similarity was not a consequence. It was not a coincidence. It was a consequence. The putting into effect of an intention that was planned and that was orchestrated. The purpose of this speech, then, is to show that a reasonable inference to be drawn from this mass of evidence points to the existence of a genocidal intent. And Mr. Reichler, following me, will tell you why it is the only reasonable inference within the meaning of the jurisprudence of this court. As I mentioned on Monday, it is invariably the case that in the absence of a published plan, a genocidal intent falls to be established on the basis of convincing circumstantial evidence. Myanmar did not document its genocidal plan by way of a direct or written evidence, and I can't take you to a written plan. Although I have to say, the Facebook messages we were taken to by Mr. Suleiman earlier this week do look very consistent with the existence of a plan. But what I can take you to is the circumstantial evidence, the nature of the acts, the manner in which they were perpetrated. And we say that that evidence is fully convincing in terms both of the particular circumstances of individual villages and the broader pattern of conduct of the clearance operations across the whole region. Mr. President, in determining the existence of a genocidal intent, the court's previous judgments, with which I am very familiar, provide important guidance. The critical parts of the court's previous jurisprudence on genocidal intent may be found in paragraphs 296 and 373 of the court's Bosnia judgment. And the court's approach was then repeated and clarified in the Croatia judgment, in particular at paragraphs 142 and 145. These paragraphs, when you take them together, clarify very helpfully the process of how this court will look at the facts and determine and infer the existence of a genocidal intent from circumstantial evidence. And I can assure you, as my colleagues have, that the Gambia has paid the closest possible attention to the court's words. The court has set out key factors. Paragraph 296 of the Bosnia judgment identifies the factors to which the court will have regard in determining whether there was a genocidal intent to destroy the Rohingya group as such, in whole or in part. And I quote, "The court now turns to the requirement of Article 2 that there must be the intent to destroy a protected group in whole or in part. It recalls its earlier statement of the law, and in particular, the three elements there discussed: substantiality, the primary requirement, relevant geographic factors, and the associated opportunity available to the perpetrators, and emblematic or qualitative factors." Three key factors. Substantiality was then further explained in the 2015 judgment at paragraph 142, and I quote, "The destruction of the group in part, within the meaning of Article 2 of the Convention, must be assessed by reference to a number of criteria. In this regard, it held, in 2007, that the intent must be to destroy at least a substantial part of the particular group, and this is a critical criterion. The court further noted that it is widely accepted that genocide may be found to have been committed where the intent is to destroy the group within a geographically limited area, and that accordingly the area of the perpetrator's activity and control are to be considered. Account must also be taken of the prominence of the allegedly targeted part within the group as a whole." Now, having cited from the ICTY judgment in Kurstic, the court then stated as follows: "In evaluating whether the allegedly targeted part of a protected group is substantial in relation to the overall group, the court will take into account the quantitative element as well as the evidence regarding the geographic location and prominence of the allegedly targeted part of the group. And it must be emphasized, the quantitative element relates to the part of the group that is targeted, not the part of the group that as a result is in fact destroyed. Substantiality is a matter of intent, not actus reus." So, to recap, for a genocidal intent to be inferred, the 2007 judgment identifies three elements. First, substantiality, which the Bosnia judgment characterizes as the primary requirement, clarified in the Croatia cases requiring assessment of the quantitative element. Second, relevant geographic factors and the associated opportunity available to the perpetrators. And third, emblematic or qualitative factors, including the prominence of the targeted part of the group. And we say all three of these elements are plainly met in this case. Paragraph 373 of the Bosnia judgment set out the standard of proof to establish genocidal intent from circumstantial evidence by reference to these three elements. It does so by reference to two distinct approaches in the absence of direct evidence of a general plan. First, the specific intent to destroy the group in whole or in part has to be convincingly shown by reference to particular circumstances. The requisite standard in this case is that the proof must be convincing. And second, and distinctly, the court states that for a pattern of conduct to be accepted as evidence of its existence, it would have to be such that it could only point to the existence of such intent. This distinction is really important. It may be that there are particular circumstances, perhaps in respect of a single incident or place, that was the case in relation to Srebrenica, that are enough to show convincingly, on their own, and without any need to have reference to any pattern of conduct, a genocidal intent. Or it may be that there is a wider pattern of conduct from which genocidal intent is the only reasonable inference. Or it may be, third possibility, and we say that's the case in the present matter, that there exist both particular circumstances established by convincing evidence, for example, in relation to each of the three villages separately, and a pattern of conduct that establishes genocidal intent as the only reasonable inference. I'm now going to address the application of each of these identified features to the circumstances of the present case. Substantiality, first. On the quantitative element, let me reiterate what I said on Monday and what Mr. Lowenstein has repeated this afternoon. Genocide is not a numbers game. There's no minimum of victims necessary for genocide to have been committed. You don't have to have destroyed all of a group, or even most of it. What matters is that the targeted part of the group that is intended to be destroyed, that is substantial, so that the targeting of that part is, and I quote from your judgment in Bosnia, significant enough to have an impact on the group as a whole, end of quote. And I'm sorry to say that substantiality is convincingly established in the present case. The number of Rohingya targeted during the Tatmadaws clearance operations was, by any reasonable standard, very significant, very substantial. This is because of the sheer number of villages attacked over the two waves of clearance operations, the number of people living in each of those villages, and the nature and extent of the attacks in each of those villages. I have to say, we find it difficult to imagine that this court could reasonably conclude that the number of Rohingya who were targeted and then actually the subjects of attacks could not be characterized as significant. According to the UNFFM, the second wave of clearance operations alone, which began on the 25th of August 2017, resulted in at least 10,000 deaths. And some estimates have stated a figure more than twice as high as that number. That's just the second wave of clearance operations. It's also, of course, as you've heard, highly relevant that many children were targeted explicitly and killed. And you're going to hear specific accounts from the witnesses next week on that kind of targeting. And that is not targeting as counter-terror activity. As the joint interveners make clear in their very persuasive submission, children are essential to the survival of the group. So that the specific targeting of children, which is fully established by the evidence before you, is fully indicative on its own of an intent to destroy a substantial part of the group. The clearance operations were also conducted on a significant scale, and this too bears on the quantitative aspect of the court's assessment. The UNFFM verified through multiple sources that clearance operations took place in at least 54 different locations, with accounts of other clearance operations in a further 22 locations. Those operations all took place at around the same time. What an amazing coincidence. And that is totally consistent with a coordinated and pre-prepared plan of action. It is on its own reflective of a particular intention. You don't accidentally attack 76 different sites at the same time. That requires planning and coordination. Their widespread and concurrent nature indicates that they were planned acts of violence. These were not operations that were reactive to incidents that occurred, and that is not even argued. I have to say that Myanmar's evidence to the contrary on this really is hopeless. There were large-scale massacres, in the words of the FFM, and they were against a substantial part of the Rohingya group. And this is all confirmed by the language of the Facebook posts which you saw earlier in the week. 2 of the FFM's indicators of genocidal intent are, we say, especially significant in this respect. The extreme brutality of the acts, first. And second, the sheer nature and scale and embrace of acts of sexual violence. Sexual violence is not ever an act of counter-terror or insurgency. And it is these elements that evoke the court's observations in Croatia versus Serbia, that in relation to a pattern of conduct, genocidal intent can be inferred from, and I quote, the scale and allegedly systematic nature of the attacks, the fact that the attacks are said to have caused casualties and damage far in excess of what was justified by military necessity, the specific targeting of members of the protected group, and the nature, extent, and degree of the injuries caused to the protected population. And I apologize that we've come back more than once to this language, but it's absolutely central to establishing a genocidal intent. Mr. President, any assessment of the quantitative aspect of substantiality in this case must take account of the overall scale of the timing of the attacks within each location and numerically across so many different locations and their systematic nature. The evidence before the court reflects a common purpose to destroy the Rohingya group, in whole or in part. Let me put it as a question on the basis of what you've heard. Would you say that it's a reasonable inference from the evidence before you that the intention was to destroy the group in whole or in part? That is a personal question for each of you to reflect upon and for each of you to come to your own conclusion. But can that question really be answered in the negative? We really think it cannot. And that is the first step to finding genocidal intent. A reasonable genocidal intent. Let me put it another way. Even if, contrary to what is required by the law, even if one were to take the narrowest of focuses on the number of actual victims, rather than on the size of the targeted part of the protected group, then the number of Rohingya alone killed by the Tatmadaw clearance operations was at least as substantial in respect of the group as the number of Bosnian Muslims killed at Srebrenica. As you know, painfully, some 8,000 Bosnian Muslim men were killed at Srebrenica out of a total population of around 50,000. That population having swelled as people fled from nearby areas. That means around 16% of the Bosnian Muslims of Srebrenica were murdered in the genocide. Now let's look at each of the 3 villages addressed this week by the Gambia, where the particular circumstances convincingly demonstrate a genocidal intent. In Mingi, 750 people were murdered. About 400 of them were inhabitants of the villages, while others had more recently fled there, as had happened at Srebrenica. So for the inhabitants alone, it's 10% of the village's population. But if you take those who had fled to the area, it climbs to closer to 20% of the total. A population of 4,300 at the time of the clearance operation. In Chut Pyin, out of a total population of 1,200, 328 people were killed. That is the murder of some 25% or more of the entire Rohingya population. In Mang Nu, the total population of the village at the time of the clearance operations is not as clear, but the UNFFM describes there being about 400 households, and 100 people were killed in that village. That means 1 in 4 households had someone killed. That is, by any standard, a substantial number. But it's not only the number of deaths that's going to be relevant. As Mr. Lowenstein set out, the killings are just one of the elements of the actus reus of genocide. As the evidence before you makes plain, there were acts of other kinds that took place. Hundreds of Rohingya women and young girls were subjected to sexual violence. Hundreds of thousands of Rohingya were forcibly displaced from their homes. Cox's Bazar in Bangladesh is currently home, it's a staggering figure, to about 1 million Rohingya refugees, making it the largest refugee camp in the whole world. And at least 178 Rohingya villages have been totally destroyed. Not damaged, totally destroyed, burned to the ground. And what that means is there is no village to which any of the survivors, tens of thousands of them from those villages, will ever be able to return. I really invite you to focus on what it means to have 178 villages destroyed. Nothing on that scale, nothing close to that scale, happened in any part of the Yugoslavia conflict. Not in Bosnia, not in Croatia, not in Serbia. The nature, timing, and scale of these operations is vast, and it makes clear that it targeted a substantial part of the Rohingya community. And the sheer numbers of the targets show beyond any doubt, not even a reasonable doubt, the existence of a reasonably inferable genocidal intent. Let me turn to the second criterion identified by the court, the geographic element of the targeted group and the opportunity that was available to the perpetrators to kill and to maim. The court has noted in a passage that I took you to earlier that it's widely accepted that genocide may be found to have been committed where the intent is to destroy the group within a geographically limited area. And what this means, according to the court, is that, and I quote, the area of the perpetrator's activity and control are to be considered, end of quote. Now, Myanmar, in its written pleadings, says that it had the opportunity to target even more members of the Rohingya community. With great respect, that is a truly horrible argument. It is made in particular at paragraphs 13.114 and 116 of their counter-memorial. Please read it, because what it seems to be saying, who knows who wrote it, is that what has passed cannot be characterized as genocide within the meaning of the 1948 Convention, because even more people could have been targeted or killed. It's not genocide, they say, because we didn't make use of the full opportunities available to us to target or to kill. Now, that really is not an attractive argument. But more importantly, it ignores the point of the court's jurisprudence, that we have to focus not on the totality of all areas, but the limited areas where the activities took place. You've said that feature is to be taken into account, and we have taken it into account in making our arguments. Although the Tatmadaw carried out clearance operations across 3 townships in northern Rakhine State, its focus was more extensive. According to data from the UN Operational Satellite Applications Programme area, the targeted area of the Tatmadaw's clearance operations stretches across more than 110 kilometres from the northernmost tip of Mungdao Township all the way to the settlements of Ko Tan Kuk and Chen Kali on the southern coast. And this covers the area, amazing coincidence, that just happens to have the largest Rohingya population in northern Rakhine State. And it's only in northern Rakhine State, of course, that the Rohingya are a majority of the population, where they make up 80% of the population. The fact that some Rohingya in other areas were not targeted in the same way cannot and does not undermine the genocidal intent that is a reasonable inference from Myanmar's actions in the geographically more limited targeted area. It is precisely to account for such realities that this court, in its earlier cases, identified the need to address the particular geographical area of a perpetrator's activities in considering the substantiality threshold, not the totality of all geographic areas. The area that was targeted in this case is a significant and representative geographical area for the Rohingya group, and its targeting is plainly of a substantial part of the Rohingya group by any reasonable standard. In respect of the opportunity available to the perpetrator, Myanmar identifies other opportunities that it says it had but did not take to kill members of the Rohingya. For example, on Myanmar's approach, you, the court, are invited to take account of the fact that there have been no killings of Rohingya in the International Displaced Persons Camp, where approximately 126,000 Rohingya have been confined, and the fact that it would have been possible to kill a lot more Rohingya inhabitants of Rakhine State, but somehow that did not happen. But the argument ignores the fact that killing is not the only genocidal act of relevance. It ignores the fact that the court has made clear that genocide may definitionally target the group in part, in a limited geographic area. And it ignores the fact that the part of the group targeted in this case, a very substantial part, were those who lived in the villages and areas set out by the UN FFM and in the Gambia's evidence. Myanmar witters on about targeting others in the IDP camps and elsewhere, yet it has targeted them, just with acts other than killing. It has confined them in camps, under conditions, with restrictions on movement, employment, livelihood, access to health care. And we say that too is genocidal in effect, because the confinement destroys the community's way of life and its culture, and the conditions to which the community is exposed are calculated to ensure their destruction as a group. The third and final consideration in respect of the targeting of a substantial part of the group is whether there are emblematic or qualitative factors which make the targeted part of the group particularly significant. And there are. You can read it for yourself in the fact-finding mission report. there was targeting of, I quote, educated, wealthy and influential men, unquote, who comprised the Rohingya leadership. They were, according to the FFM, and I quote, specifically targeted, end of quote. And so too were children targeted, as you've heard from Mr. Lowenstein, described in appalling detail. The intentional killing of children offers the clearest evidence that Myanmar's actions against the Rohingya were committed with the intent to destroy the group in whole or in part. What other reason is there for targeting children and infants? What is the justification for throwing a child into a fire pit or into a river? What is the justification? We look forward to hearing what the justifications are later in the week. And of course, the same can be said of sexual violence, which targeted so many women and young girls. The acts that have been described to you are shocking by any standard, in nature and in scale. Ask yourself the question, what was the intention of those acts? Counterinsurgency, really? In short, emblematic groups were targeted, and that offers further confirmation of the existence of a genocidal intent. I turn back briefly to the standard of proof of genocidal intent set out by the court in Bosnia, Serbia at paragraph 373. In the absence, as I've said, of direct evidence of a general plan, we have the two approaches to the standard for circumstantial evidence. Particular circumstances requiring convincing evidence, and a pattern of conduct requiring that genocidal intent is to be established on the basis of the only reasonable inference test. There's no magic to the court's formulation. And in fact, it seems ultimately to be an approach with which both parties and all the interveners largely agree. And these are pretty regular and ordinary legal thresholds familiar to anyone involved in practice before this court and other courts. But they point to essentially the same position. You've got to be sure from the evidence that the acts identified took place with a genocidal intent. And we submit that the particular circumstances of the acts that took place in Chutpien, Mingi and Mangnao, and at the other villages identified by the FFM, allow the court to conclude with really no difficulty at all that a genocidal intent is established by reference to the standard of convincing evidence because of the nature of the attacks, because of the extreme brutality, because of the extensive and sadistic sexual violence, including against children, the heinous murder of infants and children, and the substantial number of Rohingya affected in these locations. To the extent that the court needs anything more to be convinced to get you over the line, I refer you to the submissions of Mr. Suleiman on Monday, and in particular that part of his submissions that addressed, and I quote, Myanmar's clandestine anti-Rohingya propaganda campaign on Facebook, end of quote. Please go back over that material and read it against the background of what actually happened and ask yourself the question, what does that establish as the intent of those actions? The Facebook messages, the other messages circulated at the time of clearance operations offer the most graphic and compelling confirmation that these acts were plainly accompanied by a genocidal intent. And as regards the wider pattern of conduct standard, we submit that exactly the same conclusion is easily justified. This is not just across those three villages, but the three taken together with the 51 other locations identified in northern Rakhine State where clearance operations took place. Places where the Rohingya villagers were killed, where women and girls were raped and mutilated, where fleeing children were shot in the back or thrown into burning fires, and where villages and homes were razed to the ground by fire. Taken together, we invite you to ask yourself a simple question. anyone in this room can ask the question. Having regard to the totality of the evidence that you have heard this week on the acts that have been carried out and the accompanying material you have seen, is it a reasonable inference that they reflected a genocidal intent? The answer to that question is straightforward. The question answers itself. It has to be yes. And this is all the more so when you take into account the other material to which I've not yet taken you, the history of discriminatory persecution, the long-standing anti-Rohingya hate propaganda, the videos of utterances by soldiers as they carried out their atrocities, the clandestine propaganda, the destruction of evidence, and the total impunity that has followed now for almost a decade. The UN FFM assessed all of these elements, although you have more material available to you than they did. It found a strikingly similar pattern of conduct. How could it possibly have concluded otherwise? It identified 7 indicators of genocidal intent and found every single one of them to be present in the case of the Rohingya. We've taken you through those indicators over the course of our presentations this week. The FFM concluded that the inference of a genocidal intent is a reasonable one. You've got even more material than they had available to them. So we invite the court to conclude, as a first step in its analysis on genocidal intent, that it is a reasonable inference to conclude that the pattern of conduct reflects a genocidal intent. The conclusion is supported by the language of the 1948 Convention, by the interpretation and application of the Convention by this court, by other international criminal tribunals and courts, and by national courts. And in particular, I'm thinking of the courts of Germany, which have done so much to clarify and help on genocidal intent. It would be extraordinary, we say, for the court to reach a different conclusion than the FFM, namely that a genocidal intent is a reasonable inference to be drawn from all of this material. And now Mr. Reichler will set out why the genocidal intent is the only reasonable inference to be drawn from the pattern of conduct. I thank the court once again for its attention and invite you to call Mr. Reichler to the bar.
I thank Professor Sands for his statement. I now call